Why Marc Lemire must challenge the constitutionality of a law that may soon be repealed. Brian Storseth introduced his private member's bill, C-304, to repeal Section 13 and its resultant penalty clause in Section 54 of the Canadian Human Rights Act on September 30th, 2011. On June 6, 2012, Parliament repealed Section 13 of the Canadian Human Rights Act. Since that day, Bill C-304 stagnates in the Canadian Senate, where even the so-called conservative senators spoke out against the bill during its first and second readings. A full year later, third reading of Bill C-304 is still not scheduled to take place. But if Section 13 will eventually be repealed by our government, why is Marc Lemire challenging the law on constitutional grounds? There are many reasons. Let me explain each one of them. 1. If Marc Lemire simply accepts the federal court ruling of Justice Richard Mosley, then Lemire faces a lifetime free speech ban for the crime of posting a document that contains the very same information and statistics the Canadian Blood Services Agency used to ban homosexual men from giving blood. 2. Even if Section 13 is repealed by the Senate, it makes no difference to Marc Lemire's case, nor to the cases of hundreds of other Canadians already charged and convicted under this oppressive law. As absurd as it sounds, Marc Lemire could face a lifetime ban on his right to freedom of speech under a law that no longer exists. Should he refuse to abide by the lifetime free speech ban, he could go to prison. The maximum penalty for contempt of a tribunal decision is 5 years in prison. The maximum penalty for a conviction of criminal hate speech under Section 319 of the Criminal Code, just 2 years. In the entire history of the Canadian Human Rights Commission, not a single person has ever been sent to prison for violating a Canadian Human Rights Tribunal ruling, except those convicted of thought crimes under Section 13. Thomas Winicki, 9 months. John Ross Taylor, 1 year in prison, twice. Kenneth Barker, 1 month in prison. Gary Schipper, 2 months in prison. Wolfgang Droge, 3 months in prison. All because they refused to obey their gag orders. Should they violate their gag orders again, they will go back to prison. Again. If Marc Lemire wants to retain his right to freedom of speech, and let me assure you he does, then he has no choice but to challenge both the constitutionality of Section 13 as well as appeal Justice Mosley's horribly flawed and biased federal court decision. 3. It is critical for freedom of speech that Section 13 be denounced as an affront to our charter right to freedom of speech, and that the Federal Court of Appeals strikes it down as unconstitutional. Why? It will mean hundreds of cases prosecuted under this law over the past 33 years were unconstitutional prosecutions. More importantly, it will mean the penalties imposed by those unconstitutional convictions are also unconstitutional. 4. If Section 13 is declared unconstitutional, as any unbiased judge must clearly see, then those people suffering under lifetime freedom of speech bans could appeal to the court to have those bans lifted. If the law is simply repealed, then there is no avenue in Canadian law for those individuals to regain their right to freedom of speech. 5. There are multiple cases currently on hold because of Marc Lemire's case, his constitutional challenge of Section 13, and his federal court appeal of Justice Mosley's decision. These cases are at both the tribunal and federal court levels. All of the cases currently on hold will move forward the second there's a final decision in Lemire's case. 6. The Canadian Human Rights Tribunal, the body that said itself that Section 13 was unconstitutional, stopped all Section 13 cases pending the outcome of Marc Lemire's case. From the decision, I have also concluded that Section 13.1, in conjunction with Sections 54.1 and 54.1.1, are inconsistent with Section 2b of the Charter of Rights and Freedoms, which guarantees the freedom of thought, belief, opinion, and expression. The restriction imposed by these provisions is not a reasonable limit within the meaning of Section 1 of the Charter. 7. Repeal of the law does not address all the corruption and inappropriate administration of Section 13. We need a court to examine the spying, lying, and conniving of the Canadian Human Rights Commission and rule that they were out of control in both Marc Lemire's case and in many other cases as well. 8. The Senate of Canada has still not repealed Section 13, even though Bill C-304 has been in their hands for over a year. They may never pass Bill C-304 into law, so we must continue to fight for freedom of speech in the courts. Prosecution or persecution. The stated aims of the Canadian Human Rights Act are remedial, not punitive. The object of the Act is to correct discriminatory behavior, not punish. Is it remedial to refuse any and all attempts at mediation? Is it remedial to refuse to communicate with the subject of a Human Rights Act complaint? Is it remedial to continue prosecuting a man 8 years after all offending documents were removed from the Internet? No, it is not. Support Marc Lemire's defense of our right to freedom of speech. If you despise government bodies telling you what you can and cannot say on the Internet, If you despise law written for telephone answering machines being applied to all of your internet communications on any internet platform, if you believe Section 13 of the Canadian Human Rights Act violates your constitutional right to freedom of speech, then please contribute generously to Marc Lemire's Free Speech Legal Defense Fund, so he can continue his appeal and constitutional challenge of Section 13 of the Canadian Human Rights Act. Mail your generous donation in defense of freedom of speech, payable to Marc Lemire, Attention Free Speech Legal Defense Fund, 762 Upper James Street, Suite 384, Hamilton, Ontario, L9C 3A2. Or you can also donate online by visiting stopsection13.com/support.html. Thank you for your generous support in defense of freedom of speech. Together, we can repeal Section 13 and restore freedom of speech to all Canadians.